Good afternoon, and thank you for joining us for today's National Conference of State Legislatures webinar, New Waters of the United States Rule and States' Response to Jurisdictional Changes. Before I begin, I want to apologize in advance for any background noise you may hear while our presenters are speaking, including myself. Working from home often means noisy four-legged or two-legged colleagues who aren't always as courteous as our in-office colleagues. My name is Krista Hildreth, Senior Policy Specialist with the National Conference of State Legislatures and staff for NCSL's Natural Resources and Infrastructure Committee, and I'll be your moderator for today. This is the second webinar in the Natural Resources and Infrastructure Committee's 2020 Spring Webinar Series. We have a total of 3 more webinars lined up over the course of the next few weeks on a variety of topics, including solar on agricultural lands, and the preservation of pollinator habitat and soil health, an overview of traffic safety and legislative trends across the state, as well as a look at how states are meeting Clean Air Act standards as they deal with an increase in emissions from exceptional events. For a complete schedule and registration details, please visit our website at www.ncsl.org or contact me. My information will be at the end of the webinar. Before I introduce our speakers, I just wanted to review a few housekeeping items. Today's webinar is a platform for information exchange and engagement. Over the next 60 minutes, we encourage participation through our chat box, so feel free to type your questions and answer any questions in the chat box to your left on your screen. We've all had plenty of time now, it seems, to get used to these online platforms, so don't be shy. To begin building some comfortability with the chat function and to also learn who is on the line today, I invite you to type in the state from which you are calling from now. We'll hold a formal Q&A after our presentations are finished presenting. Our webinar today is being recorded, and registrants will be able to access a recording of the webinar and presentation slides on NCSL's website after the webinar completes. I'll send around a notice once those resources are made available for all interested. Additionally, you can download the presentation slides being used today, as well as the speaker bios at any time during the presentation. Now that housekeeping is out of the way, let's get back to why we're here. The Environmental Protection Agency and the U.S. Army Corps of Engineers recently finalized the Navigable Waters Protection Rule, which updates the federal definition for waters of the United States, more commonly referred to as a WOTUS. The now final rule outlines 4 clear categories of jurisdictional waters that would be considered a WOTUS, reducing the number of waters previously under federal jurisdiction. Today, we're here to learn a bit about the new rule and how states are responding. Joining us today are Mindy Eisenberg, Associate Director of Oceans, Wetlands, and Communities Division for the U.S. Environmental Protection Agency, Stacey Jensen, Assistant for Regulatory and Tribal Affairs in the Office of the Assistant Secretary of the Army Civil Works, and Krista Osterberg, Surface Water Quality Improvement Value Stream Manager for the Arizona Department of Environmental Quality. Dr. Owen McDonough, Senior Science Advisor to the Assistant Administrator for the Office of Water with the U.S. EPA, will also be on the line to answer any questions. Dr. McDonough provides technical advice and guidance on matters pertaining to water quality standards, human and ecological risk assessment, and complex science policy issues under the Clean Water Act and the Safe Drinking Water Act. This includes providing advice on the development of regulations, guidelines, methods, standards, science-based criteria, and studies that guide implementation of the national water programs. Dr. McDonough holds a BS in biology from the College of William & Mary and a PhD in wetland and stream ecology from the University of Maryland. Joining us first to provide a brief history of WOTUS and delve into the newly finalized Navigable Waters Protection Rule, we have Mindy Eisenberg and Stacey Jensen. Stacey Jensen has been the Assistant for Regulatory and Tribal Affairs at the Office of the Assistant Secretary of the Army Civil Works since 2018. In her current position, she focuses on advising the Assistant Secretary on policy for the U.S. Army Corps of Engineers regulatory program, tribal engagements, interagency coordination, and being the liaison for all Corps rulemakings, among other things. Stacey attended UCLA for both her undergrad and graduate degrees in biology and environmental science and engineering. She began working for regulatory in the LA district in 2004 and moved to the New York district office in 2007. Stacey was the regulatory program manager at core headquarters for 6 years on the topics of jurisdiction, compliance enforcement, the appeals program, and agricultural issues. Mindy Eisenberg is the Associate Director of the Oceans, Wetlands, and Communities Division in the U.S. EPA's Office of Water. The division is responsible for rulemakings, policy development, implementation activities, and grants involving the definition of the waters of the United States, the Marine Protection Research and Sanctuaries Act, Clean Water Act Sections 312, 401, and 404, building state and tribal wetland program development, and partnership programs including Urban Waters, the National Estuary Program, and the Trash-Free Waters Program. Mindy has worked with EPA for 23 years, where she served in leadership capacities in the Office of Groundwater and Drinking Water, as well as for many years in the Policy Office of the Administrator's Office. Mindy holds a Bachelor's of Arts from the University of Virginia and a Master's of Public Policy from Georgetown University. Mindy and Stacey, thank you so much for joining us today. The floor is now yours.
Thank you. So for today's presentation, we're going to provide a background on waters of the United States, take a close look at the elements of the final rule, what waters are in, what waters are out, and some definitions of terms. And we'll also highlight some differences compared to the 2019 rule, which is how the agencies implement the definition of waters of the United States prior to the 2015 Waters of the United States rule, and briefly touch on our supporting analyses, and then provide links for where you can find more information. So for waters of the United States, it's a threshold term in the Clean Water Act and establishes the scope of federal jurisdiction under the Act. The Clean Water Act regulatory programs address navigable waters, which is defined in the statute as the waters of the United States, including the territorial seas. And the Act does not define waters of the United States. Congress left that further clarification to the agencies. The EPA and Army have defined waters of the United States by regulation since the 1970s. On February 28, 2017, the President signed Executive Order on restoring the rule of law, federalism, and economic growth by reviewing the Waters of the United States rule. This EO directed the EPA and Army to review the final 2015 Waters of the United States rule, the 2015 rule, and publish for notice and comment a proposed rule rescinding or revising the rule. The EPA and Army implemented a two-step rulemaking to provide certainty to the regulated community and the public, while the agencies developed the revised definition of waters of the United States. So today's presentation focuses on that second step of the two-step rulemaking process, the Navigable Waters Protection Rule. So the agencies embarked on the effort to revise the definition of waters of the United States in March 2017. And that effort had the following key goals: operating within the legal limits established by Congress, as clarified by the Supreme Court, particularly in three key cases involving waters of the United States. Those are Riverside Bayview Homes, Swank, and Rapanos. Also, striking a proper balance between the regulatory authority of the federal government and state primacy over their land and water resources, and adhering to the overall structure and function of the Clean Water Act. Also, to increase clarity and predictability in the descriptions of what is and what is not a water of the United States. So the agencies have streamlined and clarified those waters that are waters of the United States and those that are not through 4 categories of jurisdictional waters and 12 categories of excluded waters and features. Many of the exclusions that the agencies have codified now were highlighted in the preambles of the agency's 1980s regulations. And where that was the case, these waters are generally not found to be jurisdictional under the 2019 rule. Specifying these exclusions in regulation rather than in preamble provides that greater predictability and consistency. In the final rule, the agencies combined into one category the territorial seas and traditional navigable waters. The final rule does not contain a standalone category of interstate waters, waters which cross state boundaries. Those must meet the conditions of one of the four categories of jurisdictional waters to be waters of the United States. Unlike the 2019 rule as implemented, this final rule does not require the agencies to conduct a significant nexus analysis to determine jurisdiction of certain waters and wetlands. Rather, we assess waters based on the conditions described in the four categories. Finally, the agencies have created a new category of standing water bodies by combining the historic category of impoundments with lakes and ponds, as they function similarly on the landscape. So for those first category, the territorial seas and traditional navigable waters category, the agencies have not made any changes to the definition of territorial seas or to the definition of traditional navigable waters, or TNWs, in the final rule. And we've combined these two types of waters for simplicity purposes. These are the foundational waters, such as the Great Lakes, the Mississippi River, and the federal government's authority to regulate them is grounded in the authority to regulate interstate commerce under the Commerce Clause of the Constitution. The following three categories of waters of the United States all tie back to these A1 waters for determining their status as waters of the United States. And you'll hear us refer back to them contributing surface water flow to TNWs and the territorial seas. So the next category, the second category, these A2 waters of jurisdictional waters are tributaries. And the definition is on this slide, which I'll leave for you to read. I do want to highlight, though, some key aspects of the tributary definition. In order to be considered a tributary and jurisdictional under the Clean Water Act, rivers and streams must first be intermittent or perennial in a typical year. They also must contribute surface water flow to a downstream TNW territorial sea in a typical year. They can flow through other categories of jurisdictional waters before reaching the TNW or territorial sea. Perennial and intermittent waters are jurisdictional if they're upstream of a channelized, non-jurisdictional surface water, so long as they contribute surface water flow to a downstream jurisdictional water in a typical year. The use of channelized in this context generally indicates features with a defined path or course, such as what you'd find in a non-jurisdictional ditch or the bed of an ephemeral stream. The flow must be discrete and confined to a channel as opposed to diffuse. Although these channelized non-jurisdictional features may provide a surface connection between upstream and downstream jurisdictional waters, they aren't jurisdictional themselves. The agencies have identified other situations where an upstream, intermittent, or perennial tributary does not lose its jurisdictional status. For example, this can occur where it flows through artificial features like culverts, tunnels, and dams. It can also occur through natural features like boulder fields, debris piles, or certain subterranean rivers where the largely same water daylights and then carries on downstream to a jurisdictional water. The agency's long-standing interpretation of the Clean Water Act is that tributaries that are altered or relocated are jurisdictional. And agencies are not changing this interpretation so long as it still meets the flow conditions of the definition. Altering or relocating a tributary means changing its shape or modifying its path. For example, by straightening a winding river, adding material to stabilize banks, adding features to reduce how fast the water moves, or moving an entire portion of the tributary to another channel. A relocated tributary is one in which an entire portion of the tributary is moved to a different location, as when a tributary is rerouted around a city center, to protect it from flooding, or around a mining complex to enable extraction of commercially valuable minerals. A ditch that takes only a portion of the tributary flow and channels it through upland would not be called a rerouted tributary. And we'll come back to ditches soon. I also mentioned the term typical year in the definition of tributary. This is an important concept for distinguishing tributaries under the final rule, as well as the other categories of waters of the United States. And we'll come back to that later in the presentation. So as I mentioned before, the final rule does not require a significant analysis to determine jurisdiction, which is different than how we're implementing in the 2019 rule. A significant nexus analysis, as called for under Justice Kennedy's opinion in the Rapano Supreme Court case, requires the agencies to prove that the water or wetland in question has significant physical, chemical, and biological effects on other covered waters more readily understood as navigable. Ephemeral streams are not jurisdictional under the final Navigable Waters Protection Rule, a contrast to the 2019 rule and pre-2015 rule practice, where some ephemeral streams were found jurisdictional following a significant nexus analysis. Finally, the agencies have long used the ordinary high water mark to establish the lateral limits of a tributary, and the Corps' long-standing regulatory definition is retained and codified in EPA's regulations. However, it is not in the definition of tributary, unlike the 2015 rule. The final rule contains 16 definitions of key terms that are used. Several of these are particularly relevant to understanding the definition of tributary. To provide clarity, the agencies have defined perennial to mean surface water flowing continuously year-round. Intermittent to mean surface water flowing continuously during certain times of the year and more than in direct response to precipitation. For example, seasonally, when the groundwater table is elevated or when snowpack melts. Ephemeral means surface water flowing or pooling only in direct response to precipitation, for example, rain or snowfall. The use of the term in direct response to precipitation in the definition of intermittent and ephemeral in the final rule is intended to distinguish between surface flow solely caused by individual precipitation events, including multiple individual back-to-back storms, and continuous flow resulting, for example, from weeks or months-long accumulation of precipitation in the form of snowpack that melts slowly over time, or an elevated groundwater table that provides base flow to the channel bed. The agencies are also clarifying the difference between snowpack melt and snowfall to distinguish between intermittent and ephemeral waters. Snowpack means layers of snow that accumulate over extended periods of time in certain geographic regions or at high elevation, such as in northern climes or mountainous regions. To clarify, the final rule does not mandate groundwater input as part of the definition of perennial or intermittent, which the agencies determined would too narrowly limit Clean Water Act jurisdiction over waters that provide sufficient surface water flow to traditional navigable waters in a typical year. For example, perennial or intermittent flow in certain mountain streams may result primarily from melting snowpack, not from groundwater contributions to the channel. Similarly, effluent-dependent streams may meet the definition of tributary, as long as they are perennial or intermittent and contribute surface water flow to a traditional navigable water or territorial sea in a typical year. So as you've seen, typical year appears throughout the categories of jurisdictional waters. And I want to emphasize the key point here is that it's used to support a determination of flow in the tributary, not as a milestone in and of itself. Ultimately, the goal of this concept is to ensure that when a water is being evaluated, it isn't found to be jurisdictional because of unusually wet conditions or alternatively, it isn't found non-jurisdictional because of unusually dry conditions. This is particularly important in distinguishing between ephemeral and intermittent streams and for inundation by flooding. On this slide is the definition of typical year in our final rule. Again, typical year is the key concept for establishing jurisdiction based on surface water flow between a relatively permanent body of water and traditional navigable waters, and between wetlands and other jurisdictional waters. A typical year isn't necessarily describing a period of 365 days. It could be shorter or longer depending on the water resource of interest. The agencies recognize great variation across the country in precipitation and other climatic variables like evapotranspiration, length of seasons, and changing conditions over time. So this concept allows for regionalization and variability within a national definition and helps determine what is essentially normal conditions. We will rely on a rolling 30-year period of data. For example, when evaluating whether a stream flows intermittently in a typical year, precipitation data from the current wet season could be compared to the range of precipitation that occurred during the past 30 wet seasons. In some form or fashion, the Corps has been implementing this concept for many years, from considering what are normal conditions when performing a wetland delineation and procedures for what to do when it is not considered normal, to considering the precipitation and climate record when determining flow regime conditions of a stream, for example, whether it was relatively permanent or non-relatively permanent under the 2019 rule. Although the term itself is new, the concept and application is not new. In fact, other agencies also use a similar concept, including NOAA for their climatic records and NRCS for their WETS tables and determinations of normal climatic conditions. The agencies understand the term is an area where implementation tools will be helpful for agencies and the regulated public. And that is why we are working to finalize the antecedent precipitation tool, among other sources of information to use when determining a typical year. This tool uses existing sources of information that were discussed in the preamble to the proposed rule, as well as in greater detail in the final rule. And now I'm going to turn it over to Mindy to continue on with the presentation.
Great, thanks, Stacey. The agencies have created a jurisdictional category for standing bodies of open waters that are not themselves TNWs, the lakes and ponds and impoundments of jurisdictional waters category, and the definition is on this slide. This category is similar to the tributary category that Stacey just walked through. Lakes, ponds, and impoundments of jurisdictional waters must contribute surface water flow to a TNW or territorial sea in a typical year. Lakes, ponds, and impoundments are jurisdictional if they are upstream of a channelized non-jurisdictional feature, such as an ephemeral stream or non-jurisdictional ditch, or certain other excluded waters, as long as they contribute surface water flow to a downstream jurisdictional water in a typical year. In addition, lakes, ponds, and impoundments of jurisdictional waters are waters of the U.S. if they contribute surface water flow through artificial features or through certain natural features to a downstream jurisdictional water in a typical year. A contribution of surface water flow may occur through pumps, floodgates, reservoir releases, or other mechanisms, and the agencies do not distinguish between natural and artificially manipulated surface water flow that connects a lake, pond, or impoundment with another water of the U.S. in a typical year. The key is that they contribute surface water flow to a jurisdictional water in a typical year. I also want to point out that a lake, pond, or impoundment of a jurisdictional water may also be found to be jurisdictional under the final rule where it is inundated by flooding from a territorial sea, a TNW, a tributary, or another jurisdictional lake, pond, or impoundment. This scenario may occur, for example, with certain oxbow lakes. The agencies do not mandate in the final rule text the frequency, duration, or volume of the inundation, recognizing that there is variation across the country. just that it occurs in a typical year, as opposed to flooding that occurs, say, only on a 50 or 100-year basis. The agencies are continuing to treat certain lakes and ponds as part of the tributary network. However, we are providing greater clarity about the types of surface water connections that can establish jurisdiction, whether it is flooding by inundation from another jurisdictional water or the artificial connections to jurisdictional waters like pumping or reservoir releases, as I had mentioned. With the exception of impoundments that are traditional navigable waters themselves, while both the final rule and the 2019 rule require jurisdictional impoundments to first be impounding other jurisdictional waters, such as damming a perennial river, the final rule also requires that for an impoundment to be jurisdictional, it has to contribute surface water flow to a traditional navigable water or territorial sea in a typical year. So where an impoundment does not have such surface water connection in a typical year, it's not going to be jurisdictional unless it is inundated by flooding of a jurisdictional water. So our fourth category of waters of the United States is adjacent wetlands. The test for establishing jurisdiction over wetlands differs from tributaries and lakes, ponds, and impoundments. Wetlands derive their jurisdictional status from their surface water connection to an otherwise jurisdictional water, and consistent with the 1980s regulations, an adjacent wetland cannot make another wetland jurisdictional. There are 4 ways a wetland can be found jurisdictional under the final rule, as presented on this slide. Similar to the category of lakes, ponds, and impoundments, jurisdiction can be established over the wetland if it is inundated by flooding from a jurisdictional water to the wetland in a typical year. However, flooding from the wetland to the jurisdictional water in a typical year does not establish adjacency. The agencies recognize some wetlands in the floodplains of rivers will be flooded in a typical year, and they will be considered adjacent. However, just because a wetland is in a 100-year floodplain doesn't mean it will necessarily be found jurisdictional. The inundation of that wetland by flooding from the jurisdictional water has to occur in a typical year. The agencies are also clarifying that natural berms, dunes, and similar features that separate the wetland from a jurisdictional water are indicative of the wetland being inseparably bound up with or part of that jurisdictional water. By allowing this to establish adjacency, the agencies are recognizing that such features are evidence of a dynamic and regular direct hydrologic surface connection between the waters and those wetlands. In the fourth condition for establishing adjacency, as well as with the other categories of waters, the agencies recognize that there is significant human modification of systems and that a direct hydrologic surface connection can occur through artificial features and not sever the wetland connection from the otherwise jurisdictional water. Finally, the rule provides that an adjacent wetland is jurisdictional in its entirety, when a road or similar artificial structure divides the wetland, as long as the structure allows for a direct hydrologic surface connection through or over that structure in a typical year. A direct hydrologic surface connection can be provided through a culvert or similar feature. It's important to note that the agencies have not modified our long-standing definition of wetlands. So before determining if a wetland meets one of the conditions of adjacency under the final rule, we would first need to see if the wetland met the regulatory definition of wetland. In other words, it has the appropriate hydrology, vegetation, and soils. The agencies have changed our tests for determining whether a wetland is adjacent compared to the 2019 rule. As noted earlier, the final rule does not require a significant nexus analysis to determine adjacency. And the agencies also will no longer use the long-standing interpretation of neighboring, bordering, or contiguous, but rather a wetland must meet one of the four conditions in the final rule's definition and not be excluded under paragraph B of the final rule, which I'll come to momentarily. Another key difference from the 2019 rule is that wetlands physically separated from a jurisdictional water by an artificial feature where there is no direct hydrologic surface connection are not adjacent wetlands. Under the 2019 rule, wetlands may be found adjacent based on a subsurface connection. Ditches. After considering public comments, the agencies are defining the term ditch, but are not finalizing a separate category for jurisdictional ditches. Rather, ditches are jurisdictional where they are traditional navigable waters, are either constructed in or relocate a tributary, or are constructed in an adjacent wetland and satisfy the flow conditions of the tributary definition, or if they're constructed in an adjacent wetland and develop wetland characteristics. For ditches constructed in an adjacent wetland, the agencies note that if a ditch then continues on through upland to flow into a jurisdictional water, that downstream portion will still be jurisdictional, even if it was constructed in upland, so long as it has either intermittent or perennial surface water flow in a typical year. A key point is that the wetland has to already meet the definition of adjacent wetland. The ditch cannot bring an otherwise isolated wetland into jurisdiction. All other ditches are excluded, and this is also articulated in paragraph B of the final rule. We find that the final rule provides greater clarity over the treatment of ditches compared to the 2019 rule by codifying clearly which ditches are and are not jurisdictional. Overall, the agencies expect fewer ditches will be jurisdictional compared to the 2019 rule. And as always, the burden of proof is on the agencies to determine if a ditch meets the definition of waters of the U.S. So as Stacey mentioned, to complement the four categories of waters of the United States, the agencies are also codifying 12 exclusions from the definition and regulation under the Clean Water Act. Many of these waters and features are long-standing exclusions from the definition. The agencies have attempted to balance the list of excluded features that are very familiar, such as the waste treatment systems or prior converted croplands, with not wanting to include an exhaustive list that could create confusion if a feature is mistakenly not listed. Many of the exclusions refer to upland, which the agencies have defined in the final rule. In addition, the agencies are clarifying that where a feature is constructed or excavated in a non-jurisdictional water, as opposed to just upland, it is excluded. So, for example, an artificial pond constructed in a non-adjacent wetland would be excluded. Where an exclusion is for a feature constructed or excavated in upland or non-jurisdictional waters, the feature must be created wholly in upland or in non-jurisdictional waters. Features that are partially constructed in upland or in non-jurisdictional waters could potentially meet the definition of waters U.S. However, the mere interface between the excluded feature constructed wholly in upland and a water of the U.S. would not make that feature jurisdictional. For example, a non-jurisdictional ditch that connects to a tributary is not rendered jurisdictional just because it connects to it. As discussed earlier, there are certain excluded waters that can provide for a surface water connection between an upstream jurisdictional water and a downstream jurisdictional water in a typical year. These include waste treatment systems, stormwater control features, ditches, and channelized ephemeral features. The use of channelized in this context generally indicates features with a defined path or course, such as a ditch or the bed of an ephemeral stream. The flow must be channelized in the sense of being discrete and confined to a channel as opposed to diffuse, non-channelized flow. In the resource and programmatic assessment that accompanied the final rule, the agencies evaluated the following Clean Water Act programs to consider how a change in the definition of waters of the United States could affect these programs. If you're interested, I encourage you to read the supporting analyses, both the resource and programmatic assessment and the economic analysis for the final rule, including the appendix that presents the agency's research regarding state implementation of Clean Water Act programs, definitions of state waters, the scope of state jurisdiction, and additional information on state-level regulations and policies that affect waters of the state. We have received questions from state environmental agencies about potential effects on Clean Water Act funding programs, and we want to clarify that we don't see them being affected by a change of jurisdiction under the new rule, including Section 106 funds, which support a number of Clean Water Act programs. The Clean Water Act authorizes funding for states, interstate agencies, and tribes to assist them in administering programs for the prevention, reduction, and elimination of pollution. Wetland program development grants are intended to assist state, tribal, and local government agencies and interstate and intertribal entities in building programs to protect, manage, and restore wetlands and other aquatic resources, regardless of their jurisdictional status. So these provide another source of funding. Also, the multi-purpose grant program for states and tribes provides funds to be used for high priority activities that complement programs under established environmental statutes. Other examples of funding available, especially for non-regulatory programs, include the Section 319 non-point source program funds, brownfields, the state revolving funds, and others across the agency. Oops, go back. So finally, for more information about this two-step rulemaking process, the published Federal Register notice and the supporting analyses and fact sheets, I encourage you to visit EPA's website listed on this slide. A longer recorded version of this presentation is available on our YouTube channel, which is also listed here. And any questions you have can be sent to either the EPA's or the Corps' email boxes. Thank you. Now I'll turn it over to Kristen.
Thanks, Mindy. Thanks, Stacey. Before I move on to Krista, I want to ask both of you if you are okay with answering a few questions now, just because you guys have to hop off a bit earlier. Is that okay?
Sure.
Awesome. So we have a question in the chat box from Rep. Eisenhart of Iowa, and he asks, who decides the breakpoint between ephemeral and intermittent waters?
So the day-to-day implementation of the 404 program is run by the Corps. So if an applicant comes in for approved jurisdictional determination or a permit, the Corps would be using a variety of data sources, including data that could be provided by the applicant to make that determination. Stacey, do you want to add anything?
No, that's right.
Okay.
Great, thank you. And then I'll lead with one and we'll go into another one that we got from Rep. Eisenhart. So I'll just start with his. Representative also asked, which if he doesn't mind, I'm going to reword a bit, and this is directed at Mindy, Stacey, and Owen. Can you guys talk a bit about the Supreme Court's recent ruling in the County of Maui versus Hawaii Wildlife Fund and how that may impact the WOTUS rule?
Yeah, this is Owen McDonough from EPA. I'm happy to take a first crack at this. What's important about the Maui case is that it's really, the question that was presented before the court was not a question of whether or not the water body at issue was jurisdictional. In fact, it's clearly jurisdictional. The pollutant migrated to the Pacific Ocean, but the question at that case was whether or not the Clean Water Act requires a permit when pollutants coming from a point source are conveyed to navigable waters, not directly, but by a non-point source. And again, in that case, it was groundwaters. So the ruling in Maui really doesn't have implications directly to what is and what is not a water of the United States. The question there is whether or not the migration of pollutants from point sources that get to waters of the United States indirectly through non-point sources would require a 402 National Pollutant Discharge Elimination Systems permit. I think that would be, so at a high level, there was no specific implications for the decision in Maui on the definition of waters of the United States, not in the Navigable Waters Protection Rule or arguably any other previous definition of waters of the United States.
Thanks, Owen. And if Rep. Eisenhart has any other questions, I'll direct him accordingly. And one final one for you all. If we do see courts start to freeze implementation of the Navigable Waters Protection Rule, as we saw significant legal action with the 2015 rule, we are continuing to see legal action regarding various steps of the repeal and replace. Guess what rule or guidance would become active, and how does that differ from the Navigable Waters Protection Rule? I'm assuming it's the guidance issued prior to the 2015 WOTUS rule, but want to get a clear answer on that for some of our state members on the line.
So, Owen, were you going to take that?
Sure. Yeah, I'm happy to take that. And if you want to follow up, Mindy, we can do it that way if you want to fill in any gaps.
Sure.
But waters of the United States, if there's one thing for certain about it, it will be litigated. It's a litigation magnet, and we've already seen a couple of challenges to the Navigable Waters Protection Rule, and let's not forget that there are outstanding challenges before multiple district courts on both the 2015 rule as well as the Step 1 repeal rule. That being said, we believe that the rule that we have written, given that it is grounded in the statutory text and structure of the Clean Water Act, the Supreme Court precedent out of Riverside, Swank, and Rapanos, and is clearly written, we believe that it is developed in a way such that it will stand the test of time before the courts. But in the meantime, if there is an instance in which there are preliminary injunctions in place in certain states across the country, as we saw, for example, under the 2015 rule, we expect that what would go back into place would be the pre-existing codified CFR definition that was the result of the Step 1 rule, that being the pre-2015 rule regulations, also known as the 1980s regulations or the post-Rapanos regulations.
And this is Mindy. I would just add that if there is a preliminary injunction, we will update our map that we used to have up on our website to show where the Navigable Waters Protection Rule is in place and likely where the Step 1 2019 rule is in place. So we're keeping a close eye on all the assorted litigation.
Great, thank you both. I want to thank you guys again for joining us today. I know that you all have to hop off a bit earlier for previous engagements, but I wanted to thank you for joining us. And if any participants have any questions for EPA or the Corps, please let me know and I can connect you accordingly to Mindy, Stacey, or Owen. Now just to close us off, we have Krista Osterberg. She's joining us today to tell us a bit about what Arizona's Department of Environmental Quality is doing in light of the new rule. Krista has been with ADEQ for 14 years, managing and working with a full spectrum of surface water and Clean Water Act programs. She has her MS in Water Resources and 2 BSs in Natural Resources Management and in Animal Sciences, all from the University of Connecticut. And in her spare time, she loves trail running with her Blue Heeler through Arizona's mountains and deserts. Krista, thank you again for joining us today, and the floor is now yours.
Thanks so much for having me. Can everyone hear me okay?
Yes.
Here. Yes? Okay. I couldn't tell if I was unmuted. All right. Well, thank you, Mindy and Stacey, for walking us through the changes to the WOTUS definition. I think you guys did a great job, and I will not belabor any of your points. Slides moving here. All right. So again, like I said, I think Mindy and Stacey did a great job of walking us through the categories of waters that will now be jurisdictional or not jurisdictional under the new rule. And I'm just going to talk to you guys a little bit about what we think this means for Arizona, our response to the rule, and what we are doing to ensure that we will be able to protect our important non-WOTUS waters once this rule does go into effect. So generally speaking, Arizona, back you can see this quote is dated from 2017 when EPA and the Corps originally started doing outreach on this effort to update the definition of WOTUS. Arizona supports this rule change and agrees with the notion that there are some waters that perhaps can be better protected and more appropriately regulated by the states themselves. Our governor has expressed support for this approach from the beginning, and we recognize and welcome the opportunity for Arizona to identify ways to protect our non-WOTUS waters. We also acknowledge that the rule could pose some challenges for us in terms of implementation and leave us with some short-term gaps in two areas, in terms of waters that are regulated and in terms of our existing regulatory authorities. So I'm going to walk through that in a bit more detail in my coming slides. One of the biggest questions for us as a state, and I think for most states, that we're looking at answering to try to give us that clarity of what is and what isn't jurisdictional under the Clean Water Act. Kind of 2 big questions that we're looking at answering as a state. One is, where are our traditional navigable waters? And 2, how do we assess that typical year concept of flow across the many ephemeral breaks that we have in our waters in Arizona? And I'll talk about the ephemeral breaks first. I think it was Mindy that talked about this in some detail, but this is a big concern for Arizona. So we have a lot of ephemeral waters in our state. We estimate anywhere between 85 and 90% of our water courses are ephemeral. And when I say ephemeral, that means they only flow in response to rainfall. So that's the vast majority of our waterways. And not only do we have a lot of waterways that are wholly ephemeral, we have a lot of ephemeral breaks in waterways that are otherwise intermittent or perennial. It's very, very common for us. And it's not just an issue that we see in remote areas or in first order or headwater streams. We have some of our major rivers in the state that are dry, significantly dry for most of the year. And that's due to a lot of reasons. Arizona's been in drought for decades, so that's certainly a contributing factor. But also damming up of waterways to create recreation areas and lakes, groundwater pumping for irrigation, domestic uses, and there's lots of reasons for that. But again, this isn't just small streams we're talking about. If you're familiar with the Phoenix area, The Salt River is a major river that runs through Phoenix, and it's dry for most of its length in that area. And upstream of that ephemeral break, we have significant wet waters, such as Oak Creek in the Sedona area, if you're familiar with the Sedona at all. So we're really looking at not just what waters won't be jurisdictional because they're ephemeral, but what upstream waters might potentially be severed from jurisdiction, and what does that mean for us, and what's our ability as a state to continue to protect those waters. Here's another example, the Gila River. We joke we have a picture of this hanging in the office where someone scrolled mighty, so it's the mighty Gila River. But again, significantly dry through most of its life in the state of Arizona, and that's important not only for us and looking at Arizona waters that are upstream of this ephemeral stretch, but also our upstream states like New Mexico. Gila River watershed is in New Mexico as well, so it's got implications not just for Arizona but for other states too. The other significant question is kind of the traditional navigable waters question. So what this map here is kind of our first pass guess of what we think is definitely going to retain Clean Water Act jurisdiction in Arizona. The waters that are green on this map are waters where the Corps has made traditional navigable water determinations. Again, for the state of Arizona, and I don't believe for any state, the Corps has not done a comprehensive assessment of every traditional navigable water in the state. So these are the ones that we are currently aware of. Most of these were done through approved jurisdictional determination processes. I think we only have 3 or 4 that are standalone determinations. But that's what you see in green here. And then the blue are waters that are perennial or intermittent tributaries based on our best flow regime data to date. So this is what we think stays in. But again, we don't know where all of those TNWs are, so that changes the equation as well. Certainly for some of those dry stretches of our major rivers as well. If any portions of those major rivers upstream are TNWs, that does retain jurisdiction of a lot of the upper watersheds. So that's our jurisdictional waters gap. So waters that are either out because they're not a tributary to a TNW or because they're severed by an ephemeral break. I'm going to talk a little bit about our programmatic gap, and I won't go into a lot of detail on this slide. This is really just meant to be kind of a visual before and after. What you see on this slide is kind of the suite of Clean Water Act authorities, and these are the authorities that we use to protect waters in Arizona. We've been operating under the current, the 80s definition of WOTUS all along. 2015 never went into effect in Arizona. And so we've been able to apply these programs to basically the full suite of waters of Arizona, including ephemerals, as long as there is a significant nexus. And we talked about that concept a bit earlier. So this is really just to show kind of the before and after of what we have now in our toolbox to protect waters in Arizona, and what we will retain at the state level to be able to protect non-WOTUS waters. So I'll just walk quickly through our existing state authorities for non-WOTUS waters. We do have the authority in statute to establish water quality standards for non-WOTUS waters. What's interesting about that is we have not used it. All of our surface water quality standards on the books are defined in rule as applying to waters of the United States. Again, as I said, under the previous version of WOTUS that we are currently operating under today, and under which those standards were established, that did include ephemeral waters as long as they had a significant nexus. So we've been able to apply standards to a variety of types of waters in Arizona up to this point. But moving forward, it's lucky for us and good for us that we have the ability to establish those standards, but we don't have them on the books yet. And it won't just be a simple matter of kind of taking the existing Clean Water Act or WOTUS standards and applying them to our non-WOTUS waters, because our regulatory authority to create those standards for non-WOTUS waters looks a little bit different. There's a couple different requirements for us that we don't have under our Clean Water Act authority. We do have the ability to monitor waters once we have those standards in place to compare the values to, but that's about where it ends. If we find a problem, if we monitor a state water, find that it's not meeting those state established standards, We do have some enforcement authority, but we don't have any tools in the toolbox in terms of requiring permits for discharges to non-WOTUS waters. We don't have any authorities that allow us to do any sort of watershed planning or TMDL equivalent or anything like non-point source where there's funding and support provided for restoration efforts. We don't have those things in our toolbox right now. So what we are doing to try to fill that gap, so close the programmatic gap so that we can protect the waters that are in the jurisdictional waters gap, is we're looking at creating a comprehensive state surface water protection program. Like I mentioned on the previous slide, we have a few authorities in our back pocket. We have some other state programs that lend some protection to surface water. We have our aquifer protection program that does require permits to discharges to the surface if they will eventually impact an aquifer. But that's really designed to protect aquifers as drinking water sources. So the standards associated with that are geared toward drinking water MCLs and protecting water as a drinking water source, which is excellent, but not the only important use of water. So I'll talk a little bit about where we are in this process. We started our public engagement, our stakeholder efforts back in the fall. As you might imagine, there's a lot of disagreement on what this program ought to look like in Arizona, but generally there is very strong agreement that some sort of program is necessary to make sure that we've got ways to protect our waters, particularly those wet waters that I mentioned earlier that could be severed from jurisdiction by an ephemeral break, that are important, recreation areas, important for wildlife and for a variety of reasons. What we are hoping to do with this approach is really take this as an opportunity to look at Arizona's unique environment. Again, we're a very naturally arid place. We've been in a drought for decades that absolutely impacts the way that water is used and flows and behaves in our state, and the way that it needs to be protected. So the approach that we're trying to take with this effort is really look at maybe outside the box ways or different ways that we might regulate discharges, including, are there scenarios where a discharge to a water might not need a permit? Are there areas where we want to encourage discharges to potentially improve water quality or enhance water quantity? So a lot of things on the table at this point. We are in pretty early stages, and I'll talk a little bit about our timeline as well in a couple slides. So what we're focused on right now is really trying to come up with a program outline. I mentioned earlier, we only have a few authorities that we can play with right now. So we anticipate, in order to have a robust program that really gives us the ability to protect waters, we will probably need additional authorities, including permitting. And that's something that we'll have to go before our legislature for. So to prepare for that, we're trying to really get a good outline together of what are those pieces, what will this program include, and what additional authorities might we need. And some of the things we're talking about now are what waters will fall within the scope of the program. I don't think that Arizona is unique in terms of our definition of waters of the state. It's very broad, and it includes some terminology about, natural and artificial accumulations of water. So I've heard people, claim that you could interpret that to be a puddle in your driveway after it rains or your swimming pool. Certainly not the desire or the intent of the state to regulate water bodies of that nature. So really trying to just make sure that we're providing clarity and certainty to our stakeholders and to our permittees of what this program will cover. And again, that regulatory permitting approach, what does that look like? Standards, monitoring, we have those authorities, but what other authorities might we need to be able to do watershed planning or plan restoration projects or even provide funding to implement restoration projects and things of that nature. And then, of course, the ever important, how the heck do we fund this thing and what's it going to cost? Definitely nice to hear, and I've heard this before, but not directly from headquarters in that way, that EPA does not anticipate changes to funding for state programs, so that's definitely encouraging. But we're working right now with stakeholders, our sister agencies. We have we call them fireside chats with some of our neighbor states, trying to learn, what they're doing, what programs they use, what works well for them, and also seeking input on how to best engage tribes. Of course, we have tribal consultation as an agency, but we met recently with our tribal leaders to determine how they'd like to be best engaged as we move forward as well. So as far as the timeline goes, I apologize, this slide is a little bit out of date, but we're really focused right now on a meeting with our stakeholder advisory group, our sister state agencies, to help us develop this initial program outline. The goal would be to have that to our governor's office by the end of the summer so that we could potentially pursue any additional needed authorities in the next legislative session. That is a pretty aggressive and tight time frame, but it's one that we are pretty devoted to trying to meet. And you'll see at the end of this timeline that 2023 is our anticipated date for program implementation. So that does potentially leave us with a gap if the new rule does go into effect June 23rd. We don't really anticipate having a state level program that can fully fill that gap, potentially for another 3 years. So that's definitely been something that the stakeholders have raised concerns about. I mentioned earlier, we have the ability to monitor, we have the ability to enforce against standards, we have the authority to create those standards. We do have some other state aquifer protection permits and waste and nuisance authorities that will help us in the meantime, but we're really focused on getting a comprehensive, well put together program in place so that we can continue to protect our waters in Arizona. And that is all I have. So thank you for having me today.
Thanks, Krista. That was great to hear what Arizona is doing, how they're developing their program. I've got one quick question for you before we start to let people go because we're a little over. But from an agency perspective, no worries. It's a good thing that we're over. From an agency perspective, right, there's only so much that a state agency can do without approval from the legislature, approval and funds. For example, the agency could develop a new water quality standard, but a permitting program could require legislative action. Has Arizona had to consider that in their program development? And if so, how?
Absolutely. So I mentioned earlier, we don't have the authority for a permitting program right now. So if we want to permit discharges to non-WOTUS waters, we will have to get that authority from our legislature. So the goal of this program outline that we're working on now is not only to identify what are the key components of the program, but what additional authorities or modifications to existing authorities might we need to be able to have those program elements and have the authority to be able to have the program that we're outlining.
And I'm sure we have many other states across the board whose agencies could also be dealing with a similar situation. So that's good to hear, and I'm sure our legislatures know that action such as that could be coming down. So as we close, I'd just like to extend a final thank you to our presenters. Krista, I think you might be the only one left with us, but we greatly appreciate the expertise that each of you were able to provide. And of course, a thank you to all of our attendees for participating in today's webinar. As a reminder, a recording of the webinar and the presentation slides will be made available shortly. Our next webinar will be in 2 weeks on May 21st at the same time on solar on agricultural lands, preserving pollinator habitat and soil health. As interest in farmland solar has grown, so has the concern over its potential environmental and food impacts, and in particular its impacts on pollinators. Fields that are cleared for solar installations can harm pollinators that depend on vegetation for habitat and food. Solar installations can also harm soil health by increasing erosion. So join us in 2 weeks and learn if agriculture, solar, and pollinators can coexist in a way that benefits all three. And to register or find out more information, please visit ncsl.org or send myself, Kristen Hildreth, an email. Again, thank you for your continued interest and support of NCSL, and have a great day.